Hi, my name is Ricardo, and in today's video we're going to talk about commission-based fundraising. Now, I know that this may be a contentious topic, but I'm going to look at it from the perspective of legislation. In particular, I'm going to look at it taking into account Section 30 and Section 18A of the Income Tax Act. So there are other laws that are applicable when you engage in commission-based fundraising. For example, if the organization is incorporated as a non-profit company, then the provisions of the Companies Act are applicable. If it's registered in terms of the Non-Profit Organizations Act, then those provisions are also applicable to commission-based fundraising. And then there are other two important laws that are applicable in my view. The one is the Protection of Personal Information Act, and the other one is the Consumer Protection Act. So I'm going to briefly comment on two provisions, being Section 30 and Section 18A. Now, Section 30 is applicable to approved public benefit organizations. There might be other exempt organizations, tax-exempt organizations, but I'm focusing specifically on public benefit organizations that are approved. Now, Section 30 is relevant because that's basically the gateway section. Tax exemption is dealt with under Section 10 of the Income Tax Act, and there's one section, Section 10(1)(c) in, that refers to Section 30. And it says that in order for an organization to become an approved public benefit organization, it must comply with the requirements of Section 30. But it must also, continue to comply with those requirements whilst it is an approved public benefit organization. So let's look at one of the subsections in terms of Section 30, and that is Section 33D of the Income Tax Act, which prohibits the payment of any remuneration as defined in the fourth schedule to the Income Tax Act to any employee, office bearer, member, or other person which is excessive, having regard to what is generally considered reasonable in the sector and in relation to the service rendered. And it has not, the organization now has not and will not economically benefit any person in a manner which is not consistent with its public benefit objective. You might say that, look, commission is not remuneration. Now, that in the broader sense might be true, but if we look at the definition of remuneration as defined in the fourth schedule of the Income Tax Act, any amount of income which is paid or is payable to any person. Keep in mind it's to any person, so it could be a natural person or legal person, by way of salary, leave pay, wage, overtime pay, bonus, gratuity, commission, fee. So keep in mind, if we stop at that point, clearly if we talk about commission payable to a fundraiser in terms of commission-based fundraising contract, that would fall within the definition of remuneration as defined in the fourth schedule of the Income Tax Act. So by implication, Section 33D would also include commission payable to a fundraiser. So now the question is, if it's applicable, to what extent the organization is limited to pay commission-based fundraising. So in my view, any commission payable must accordingly not be excessive, having regard to these following two factors: what is generally considered reasonable in the sector and in relation to the service rendered. Now, if we stop there, that's, it's a principle that's embedded now in the legislation, but it is applicable, or it must be applied to a particular set of facts. So you may have a situation, let's say, where somebody stands at the mall on behalf of an organization, and they're doing fundraising, and they might stand there for 7 hours, and the agreement is that, look, you get 20% of what you accumulate or the funds that you've raised during the day. Now, if the person got, in terms of funding, 1,000 rands, 20% of that would be 200 rands, and I don't think it's unreasonable in the sense that the person is getting too much, paid for that service. But it would be different if a person, for example, would agree upfront to do fundraising for an organization, and the organization managed to secure quite a large, let's say 20 million rand contract from a donor. Now, if the agreement with the fundraiser is, let's say 20%, and that fundraiser effectively spent, let's say, 2 weeks working on that, then the question is whether that is excessive as defined in section 33D. Now, very important to keep in mind that if the law stipulates a particular requirement, you may find yourself in a situation where that agreement is not enforceable because it's inconsistent with legislation, irrespective of whether the organization has entered into an agreement with a fundraiser. So it's very important to keep that in mind, that there are requirements in terms of section 30 dealing with, or that would have implications, for a commission-based fundraising agreement. Now, very briefly, if we look at section 18A, now keep in mind section 18A is not applicable to all public benefit organizations. Some public benefit organizations are specifically approved in terms of section 18A, so that enables them to issue receipts for donations. Quite a lot of requirements embedded in terms of section 18A, but if we look at the section itself and if we consider its implication for commission-based fundraising, let's just take this into account. Section 18A1 provides that notwithstanding any provision in terms of section 23, there shall be allowed to be deducted from the taxable income of any taxpayer so much of the sum of any bona fide donations by the taxpayer in cash or of property made in kind, which was actually paid or transferred during the year of assessment 2. Now, that 2 refers to the approved public benefit organization. So basically, what it means is that, let's say somebody makes a donation to the organization, the donation must comply with certain requirements, right? So it's not automatically eligible in terms of 18A. But what's clear in this context is that it's required of the donor to make the donation directly to the organization in order for that donation to be eligible under 18A. So you can't have a situation where if you have a third party that is doing the commission-based fundraising on behalf of the organization, you can't have a situation where that donor makes the donation firstly to the third party who hasn't got 18A status. Now that third party might be transferring the money to the organization after the deduction of the commission, but that's not what's provided for in terms of section 18A. And if we look also at the PBO guide, the following statement is made by SARS. A taxpayer may make a donation directly to a section 18A approved organization or through a payroll giving program operated by an employer. So that's in a nutshell 2 important requirements for non-profit organizations. Now, this is in the context of organizations that are approved in terms of the in terms of section 30 and section 18A of the Income Tax Act. But keep in mind there are other laws. We don't have enough time now to deal with those other laws, but check out the following video. If you like this video, please click on the like button, and if you think others will benefit from this, please share with those. Thank you so much for having watched this.